Yeah. Hello, everyone, and a warm welcome to this session on cross-border insolvency under the IBC framework. My name is Sanjay. I'm a chartered accountant and someone who works closely with insolvency cases, financial restructuring, and corporate resolution matters. Today, we are diving into one of the most complex and globally relevant aspects of insolvency law. How do we resolve insolvency when the distressed company has creditors, operations, or assets spread across borders? We'll discuss why this is becoming more important every day, how the world handles it, where India stands right now, and what's proposed for the future. So, my goal in this session is simple to give you not just theoretical knowledge, but practical clarity. Will blend legal concepts, real world case studies, and global framework so that by the end of the session, you're not just informed but equipped. So, equipped to think, to analyze, and eventually to act in a real cross border scenarios. So, let's begin with the most fundamental question. Why does cross border insolvency even matter in the first place? So, let's begin with something we all observe today. No big business is confined to a single country anymore. Be it an IT company, an airline, a logistics giant, or even a manufacturing company, they all operate globally. They have offices, clients, loans, or supply chains that span across countries. Think of a company headquartered in Mumbai. So it might have raised debt from a bank in Germany, leased equipment from a firm in the UK, and have customers in the Middle East. So the company benefits from this cross-border integration, of course, lower borrowing costs, larger markets, and access to global capital. So, but there's a flip side to this interdependence. When that company defaults, its debt doesn't disappear just in India. The creditors abroad now become directly impacted. So the assets scattered in different countries comes under dispute and suddenly multiple legal systems come into play. So in India, we have the Insolvency and Bankruptcy Code, which revolutionized how insolvency is handled within our borders. But what happens when an Indian company with significant assets in Dubai or Singapore defaults? Can our courts reach there? Can Indian creditors claim their dues in a foreign land with equal footing? Unfortunately, without a proper legal framework, the answer is it depends. And that's a problem because when courts in different countries begin acting interdependently or independently, we run the risk of chaos, conflicting judgments, aggressive recoveries, and value erosion. For global businesses, a purely domestic insolvency framework is just not enough anymore. So, Jet Airways is a case that hit Indian headlines not just for its dramatic collapse, but for the complex legal puzzle it triggered internationally. The airline had operations and creditors in both India and abroad. While Indian proceedings began under the IBC, a group of European creditors filed for bankruptcy in a Dutch court. So the Dutch court responded by appointing a bankruptcy trustee, a Dutch administrator, to safeguard Jet's assets in the Netherlands. Now comes the conflict. When this Dutch administrator approached Indian courts to be recognized and to join hands with the Indian resolution professional, NCLT refused. Why? Because our law had no provisions to recognize foreign proceedings or officials. As a result, we had two jurisdictions, both dealing with the same debtor, refusing to talk to each other initially. It wasn't until the case reached NCLAT that some degree of cooperation was permitted. So the Dutch administrator and the Indian RP entered into a cross-border protocol, an arrangement that wasn't backed by law but had to be stitched together by judicial innovation. While this showed flexibility on part of our judiciary, it also rang the alarm bells. We clearly lacked a formal legislated cross-border insolvency mechanism. If a high profile case like Jet had to be managed in an improvised way, imagine the difficulties smaller, less media covered cases would face. So, Jet Airways is not an exception. Companies like Bhushan Power, SR Steel, and Reliance Communications all have exposures abroad. When such companies faces insolvency, there are bound to be foreign stakeholders who need clarity and legal certainty. If we don't offer them that through our system, they may turn hostile, seize overseas assets, initiate litigation abroad, or simply walk away from cooperative solutions. Now ask yourself, would you invest in a company headquartered in a country where your rights as a foreign creditor are not respected or even defined? That's the real risk here. So, without cross border mechanisms, we are not just talking about legal inefficiency, we are risking our attractiveness as a destination for global capital. So, the issue of cross border insolvency is not unique to India. Every major economy that deals with global business had to deal with this. That's why over 50 countries adopted the UNCITRAL Model Law on cross border insolvency. Countries like the United States, the UK, Singapore all use this to coordinate court actions, share information, and legally recognize each other's insolvency judgments. So the model law creates a framework where a court in country A knows what to do when there's a proceeding in country B. It creates structure, predictability, and reduces unnecessary litigation. For India, adopting such a model would mean our courts, insolvency professionals, and creditors could work in sync with their global counterparts. It would mean we no longer need to improvise every time a cross border dispute arises. So, if someone asks you why cross border insolvency matters, remember this. So, global businesses come with global risks, and global risks need global solutions. So, Jet Airways showed us that without a law, we improvise. But improvisation is not a strategy, it's a temporary patch. For India to rise as a global economic power, we must have legal systems that can talk to the world. Cross-border insolvency is not just a technical issue, it's a foundational pillar of modern commerce. We'll now move to understand what exactly constitutes cross-border insolvency and how laws across jurisdictions define and handle it. Okay. Let's now try to deeply understand what cross-border insolvency really means. At its core, it refers to a situation where an insolvency company has assets, operations, or creditors located in more than one country. This isn't just limited to multinational conglomerates. Today, even mid-sized firms in India raise money from international lenders or lease equipment from abroad. So, when a company enters in insolvency, its web of international relationships becomes legally significant. Without a mechanism to address claims and coordinate between different courts and laws, we risk inconsistent and inefficient resolutions. So imagine this: an Indian real estate firm borrows money from a Hong Kong-based private equity firm. It also leases construction machinery from a supplier in Dubai. It holds cash in a Singapore-based bank account and is now under insolvency, undergoing insolvency under IBC. So the foreign lender wants its repayment. The machinery supplier wants to repossess its equipment. But all of this is unfolding under Indian insolvency proceedings. The foreign players faces two problems. One, their claims may not be recognized properly, and two, even if they are, there may be no structured way to recover their dues. This is exactly what cross-border insolvency tries to resolve. It creates systems that allow these foreign entities to be involved fairly and legally. Now let's understand two important proceedings in cross-border insolvency, main and secondary. The main proceeding happens in the country where the debtor has its center of main interests, also called COMI. COMI is where the company's core business operations take place. It's the place where management decisions are made, where creditors naturally look to initiate legal action, and often where the company is legally registered. Let's say a company is incorporated in India, holds board meetings in Mumbai, and files taxes locally. Indian creditors would expect proceedings to happen in India. This is a classic example of COMI. So, why is COMI so important? Because it creates a legal anchor, a reference point for all cross border cooperation. The country where COMI lies takes the lead, and other countries are expected to recognize the primacy of those proceedings. This principle helps avoid jurisdictional battles. In the absence of COMI recognition, every country may claim to have the primary authority to handle the insolvency, and that leads to chaos. For example, if Jet Airways had its COMI in India, but Dutch courts didn't acknowledge it, then both jurisdictions could issue conflicting rulings on asset recovery or resolution plans. Okay, next. Secondary proceedings. Secondary proceedings are initiated in countries where the debtor has assets but not its COMI. These are usually for liquidation purposes. Suppose Jet Airways had parked an aircraft in the Netherlands. Um, so the Dutch court could initiate a secondary proceeding to handle just that asset, but it would not manage Jet's entire insolvency globally. The secondary proceeding is a way for a country to protect local interests without disrupting the main process. This dual system, main and secondary, is what brings balance to cross-border insolvency regimes. It ensures that no jurisdiction is entirely left out, but also that one country takes the lead. Now, let's consider what happens in the absence of such a structure. Two courts may both try to take control. One may try to sell an asset while the other puts a stay on it. One court may approve a resolution plan while other invalidates it. This leads to value destruction, legal delays, and the worst part, investor distrust. If India doesn't adopt globally accepted norms like COMI and secondary proceedings, we will continue to face such conflicts. Foreign investors may hesitate to lend to Indian firms knowing there is no coordinated remedy in case of failure. So, when we ask what is cross border insolvency, we are not just asking a legal definition, we are discussing a global system of cooperation. It is about recognizing that businesses today are borderless, but laws still are not. This teaches us how to bridge that gap. So, main proceedings, COMI, secondary proceedings, these are all the tools that help courts and creditors talk to each other across borders. Uh, Next, we'll look at how the UNCITRAL model law takes these concepts and turns them into a structured global framework. Okay. So now that we understand what cross-border insolvency is and how COMI works, the next question is how do we get countries to work together effectively? Because laws are national, but businesses are international. This is where the UNCITRAL model law comes in. It provides a common, flexible, and internationally accepted legal framework for managing cross-border insolvency cases. UNCITRAL stands for United Nations Commission on International Trade Law, and the model law is it created is not binding by itself, but it has been voluntarily adopted with local tweaks by more than 50 countries. Okay. So, what is a model law? A model law is a template, a legal structure that countries can choose to incorporate into their domestic law. It isn't a treaty. Instead, it offers guiding principles and tested practices that can help jurisdictions work with each other without compromising their own legal sovereignty. Think of it as a toolkit. Each country can implement parts of the model law or adapt the entire thing with specific customizations. That's what makes the UNCITRAL model law successful. It respects national control while fostering international cooperation. Let's talk about the pillars. So, pillar one, access. Access is the first major pillar of the UNCITRAL model law. It says that for an insolvency professional, someone like an administrator appointed in another country, should be able to apply directly to a local court. So, let's say a UK administrator is appointed for a company that has assets in India. With access rights, that administrator can approach an Indian court to safeguard Indian assets, um, like bank accounts or leased equipment, without needing to go through complex diplomatic or consular channels. This creates legal efficiency, it cuts that red tape, and more importantly, it treats international professionals with the same respect as domestic ones. Next, recognition. Recognition is the process by which one country's courts legally acknowledge that an insolvency proceeding is happening in another jurisdiction. For example, if a company is declared bankrupt in France and the French administrator requests recognition in India, the Indian court can officially validate the French proceeding. Um, so why is this important? Because without recognition, there's legal uncertainty. Creditors may not know whether to trust that proceeding. Courts may hesitate to stay local claims or delay enforcement. Recognition turns a foreign proceeding into something legally usable in your own country. It enables protection of local assets and gives the foreign IP standing to act. Okay. The third pillar is cooperation. It's not enough to just recognize that a foreign proceeding exists. Local courts and insolvency professionals must work together. This includes sharing information, participating in joint hearings, and setting up case protocols. Take the Jet Airways example again. When the Indian enclave allowed the Dutch administrator to cooperate with the Indian resolution professional, that was an example of judicial cooperation. Even though it wasn't backed by the model law, with UNCITRAL, this kind of collaboration becomes easier and legally defined. Next one is coordination. It's the fourth pillar. In many cases, insolvency proceedings happen simultaneously in multiple countries. Let's say the main proceeding is in India, but there's also a secondary one in the Netherlands and another in Singapore. Coordination means that courts in these countries will try to align their timelines, rulings, and processes to avoid conflict. This might include protocols for how to handle asset sales, priority rules for creditor payments, or procedures for communication between courts. Coordination protects asset value and reduces delay. It gives the debtor and the creditors clarity. So you might be thinking this sounds complex, but in reality, these four principles, access, recognition, cooperation, coordination, are what make the global insolvency practical. They ensure that a company isn't dismantled piece by piece in disconnected legal battles. They promote consistency. And most importantly, they inspire creditor confidence across borders. Think of this as an orchestra. Okay. So without these rules, each court plays its own tune. With the model law, everyone reads from the same sheet of music. That's the power of these four principles. So far, over 50 countries have adopted the UNCITRAL model law, including the United States, the UK, Japan, Singapore, and Canada. It is quickly becoming the global standard and for good reason. It balances local control with international cooperation. It offers a common vocabulary like COMI, main proceedings, secondary proceedings, and it lays down principles that are both flexible and enforceable. India is one of the few major economies yet to adopt it, but as we'll see further, there is already a proposal to integrate it into our IBC under a new chapter called Part Z. Okay. So now that we have looked at how the UNCITRAL model law offers a blueprint for cross-border insolvency, let's ask ourselves, what does India have in place right now? Unfortunately, the answer is not much. That's operational. India's insolvency regime under the IBC is robust, but when it comes to it's robust when it comes to domestic issues, but when we enter the international arena, our toolkit is minimal. There are two specific sections in the IBC meant to address cross-border cases, Section 234 and Section 235. However, neither of them has been notified till date. Let's break this down and understand their intended purpose and also why they fall short in practice. Okay, Section 234 empowers the central government to enter into bilateral agreements with other countries for the purpose of enforcing provisions of the IBC in cross-border insolvency cases. This sounds good on paper. In theory, it means India could sign a deal with, say, Singapore or the UK that outlines how courts in both countries should cooperate when a company with ties to both jurisdictions becomes insolvent. But here's the catch. Not a single such agreement has been signed till now. In absence of any treaties, Section 234 remains a dead letter. Even if a need arises, drafting, negotiating, and ratifying such treaties could take months or years. Now, let's look at Section 235. This section allows the adjudicating authority in India, typically the NCLT, to send a letter of request to a court in a foreign country, asking for help in dealing with assets or claims related to an Indian insolvency case. This again sounds like a useful tool, but once again, its effectiveness depends entirely on whether the foreign country is willing or obligated to honor that request. In the absence of a mutual legal assistance treaty or a framework like UNCITRAL, such requests may simply be ignored. The result, legal uncertainty, enforcement delays, and frequent roadblocks in cross border cases. So, why have these sections not been notified or operationalized? The answer lies partly in India's cautious approach to foreign influence in domestic legal matters. There is often concern that giving recognition to foreign proceedings or allowing foreign courts to act could infringe upon our judicial sovereignty. There's also a structural reason. Bilateral agreements require extensive negotiation, legal vetting, parliamentary oversight, and interministerial coordination. Given that insolvency law is still relatively young in India, cross-border treaties have simply not been prioritized. So let's revisit the Jet Airways case again. When the Dutch administrator approached the Indian courts to be recognized, there was no functioning legal channel to validate his role. Sections 234 and 235, even though mentioned in the law, offered no help because they weren't notified and there was no treaty between India and the Netherlands. So the UNCLAD had to innovate. It permitted a cross-border protocol, an informal agreement between the Indian resolution professional and the Dutch administrator to cooperate. This was a workaround, not illegal but not backed by statute either. It reflected the flexibility of the Indian judiciary, yes, but it also highlighted how underprepared our legal infrastructure was for handling global cases. So, in absence of a clear framework, India runs several risks. One, foreign creditors may be discouraged from participating or may initiate parallel proceedings abroad. Two, assets located in other jurisdictions may be lost to competing claims. Three, cooperation between courts becomes an ad hoc exercise, leading to inconsistencies. Four, Indian insolvency professionals have no guidance on how to engage with the foreign representatives. This is not just a procedural weakness, it impacts our credibility as a destination for cross border capital and corporate transactions. Investors want legal predictability, and right now we can't offer that in the global cases. So what's interesting in that is that courts like NCLAT and NCLT have shown an openness to engage with foreign processes. The Jet Airways judgment is one example. There have also been observations by courts in cases involving foreign asset recovery or foreign claimants. However, in absence of statutory backing, these actions remain experimental. For long-term confidence, judicial improvisation must be replaced by legislative action. A functioning framework must exist, one that judges, creditors, and professionals can rely on. So, to sum up, India's current legal framework for cross-border insolvency is skeletal. Sections 235 and 234 and 235 are well intentioned but not non functional. No treaties have been signed, no rules have been framed, and no standard protocols have been issued. The result is a vacuum, one that forces every cross border case into a gray zone. This is neither efficient nor fair. As we go further, India does have a plan, a proposed new framework that could plug these gaps. So let's explore that in detail. Okay. Let's now uh, let's now discuss one of the most discussed cross-border insolvency cases in India, Jet Airways. Once a leader in India's private aviation sector, Jet had an extensive international footprint. It had leased aircraft from foreign lessors, obtained loans from global creditors, and operated international routes. This made its insolvency case not just a domestic financial problem, but an international legal challenge. As Jet struggled to pay its dues, creditors in both India and abroad began asserting their rights. In 2019, Jet Airways was admitted into insolvency proceedings by the NCLT in India under the IBC. Simultaneously, a group of European creditors initiated bankruptcy proceedings in Netherlands concerned about their interests in Jet's overseas assets. So the Dutch court appointed a bankruptcy trustee, the Dutch administrator, to protect Jet's interests in the Netherlands. This set the stage for an unprecedented situation. Two different legal systems handling the insolvency of the same entity at the same time with no formal framework in place to coordinate between. So the Dutch administrator approached the Indian NCLT seeking recognition of the Dutch bankruptcy order and his role in managing Jet's assets abroad. However, the Indian tribunal refused. Why? Because the IBC, as we have discussed, has no mechanism, no notified provision or treaty that allows for recognition of foreign proceedings or foreign insolvency practitioners. The court had no legal basis to entertain the Dutch administrator's request, and the absence of a bilateral treaty or a framework like the UNCITRAL model law made cooperation legally impossible, at least at first. So the matter eventually reached the NCLAT, which took a more progressive approach, acknowledging the global nature of Jet's operations and the practical need to work with the Dutch court. NCLAT permitted the Indian resolution professional and the Dutch administrator to cooperate under a cross-border protocol. This protocol allowed both parties to share information, coordinate actions, and jointly handle Jet's assets in Netherlands and India. But here's the important point. This cooperation was not backed by Indian law. It was a judicial innovation, not a legislative provision. It was a necessary solution, but also a temporary patch. So, this case was significant for several reasons. First, it was India's first real encounter with a simultaneous foreign insolvency proceeding involving an Indian company. Second, it exposed the limitations of our current IBC framework. And third, it showed the willingness of Indian courts to cooperate internationally, even in the absence of a statutory mechanism. Jet Airways became a landmark not because of its financial size, but because of the legal gaps it exposed. It became the poster child for why India needs to formally adopt cross-border insolvency proceedings. So there are several important takeaways from the Jet Airways case. One is about judicial flexibility. So the NCLAT showed that Indian courts are open to practical solutions even when the law doesn't provide anything explicitly. Second is limitations of improvisation. While cooperation was achieved in this case, not every case may be so fortunate. What happens when a foreign court refuses to cooperate unless recognition is statutory? Third is incentive for reform. Jet Airways added pressure on policymakers to accelerate adoption of the UNCITRAL model law or a suitable Indian adaptation. And the fourth is creditor clarity. Creators need to know that their claims will be addressed fairly, whether they are domestic or foreign. So the lack of legal clarity over their foreign dues discourages future investment. The case also highlighted how unprepared the Indian system was for global insolvency scenarios. Our professionals, judges, and even regulators had to operate in uncharted territory. So the cross-border protocol that was developed was based on mutual respect and intent, not a formal legislative roadmap. In the long run, reliance on ad hoc protocols will not suffice. We need rules, we need legislation, and we need India to speak the same language as other major economies when it comes to insolvency cooperation. So, in conclusion, the Jet Airways case acted as a catalyst. It forced stakeholders from ports to policymakers to confront the reality that India cannot afford to be silent on cross border insolvency any longer. It was a case that highlighted both the courage of the judiciary to take initiative and the glaring legislative vacuum that still persists. In in the further discussion, we'll see how India responded to this challenge through the proposal of a new framework called Part Z, designed to fill this very gap. Okay. So after this Jet Airways case and growing calls from insolvency professionals, creditors, and courts, the Indian government realized it could no longer afford to ignore the issue of cross-border insolvency. So the Insolvency Law Committee, a body constituted by Ministry of Corporate Affairs, came up with a detailed recommendation. Their proposal to adopt a framework based on the UNCITRAL Model Law and integrate it into the IBC through a new part called Part Z. Let's break down what Part Z is and how it works and why it matters. Okay, Part Z. What is Part Z? So basically, Part Z is a proposed addition to IBC that is designed to handle cross-border insolvency cases. It draws heavily from the UNCITRAL model law, but includes India's specific features to address concerns around sovereignty, regulatory clarity, and institutional capacity. So, unlike sections 234 and 235, which relied on treaties and bilateral agreements, Part Z is meant to be a standalone legal mechanism that can function with or without foreign treaties. So, this makes it faster to implement, more autonomous, and better suited for India's current global standing. Let's walk through the most critical features of Part Z. First is recognition of foreign proceedings. Part Z enables Indian courts to recognize insolvency proceedings initiated in other countries. Recognition can be granted as a foreign main proceeding or a foreign non-main proceeding, depending on where the debtor's center of main interests lie. Second is access for foreign insolvency professionals. So, foreign insolvency representatives can apply directly to Indian courts for participation, interim relief, or cooperation. And third is public interest exception. Indian courts can refuse recognition or cooperation if it is against public policy, national security, or judicial sovereignty. This gives India the right to decline foreign orders when necessary. The fourth is cooperation and communication. Indian courts and insolvency professionals are required to cooperate with foreign counterparts and may establish protocols for efficient coordination. And the fifth is the last is that no treaty is required. Perhaps the most notable feature is that Part Z does not require a prior treaty or agreement to be functional. This removes a significant bottleneck that exists under sections 234 and 235. So, under Part Z, recognition is not automatic. A foreign insolvency professional has to apply to the Indian Adjudicating Authority, which is the NCLT. The NCLT will examine whether the foreign proceedings qualifies as a main or non-main proceeding and whether it meets certain procedural and judicial requirements. Only after these checks will the court decide whether to recognize the foreign proceeding and to what extent it will allow relief. This ensures that recognition is controlled, well regulated, and subject to judicial scrutiny. A major concern in adopting a foreign legal framework is the risk of compromising national legal control. What if a foreign court's decision contradicts Indian policy? To address this, Part Z includes a public policy exception, a clause that allows Indian courts to reject recognition or cooperation if the foreign order is fundamentally inconsistent with Indian laws, sovereignty, or public interest. This ensures that while we promote international cooperation, we do not give up our ability to protect national interests when necessary. So Part Z is aligned with UNCITRAL model but includes a specific customization. One is India's specific definitions. Certain terms have been refined to suit Indian legal terminology. Greater court discretion. Indian courts have broader powers to refuse recognition, and there is no reciprocity requirement. Unlike some countries that require mutual recognition, India has chosen to proceed without such restrictions. Then administrative clarity. Procedural rules and forms will be notified to ease implementation. So these differences reflect a mature attempt to balance global standards with domestic realities. If enacted, Part Z will transform how India handles cross-border insolvency. It will provide legal clarity to all stakeholders, judicial confidence for judges handling global cases, credit assurance to foreign investors, asset protection across jurisdictions. It also enhances India's credibility in international commercial arbitration and cross-border functioning, uh, and also cross-border financing. As Indian companies grow more global and as foreign capital flows into Indian markets, such a framework becomes indispensable. So Part Z was first proposed in 2018, and since then it has received wide support from professional community. But as of today, it is still a draft, not yet enacted. There have been consultations, stakeholder feedback, and internal reviews, but no final notification. That's unfortunate because every delay means another company could go through what Jet Airways did, operating without a net. Uh, so we'll see how other countries have already implemented similar laws and what India can learn from them. Okay. Hmm. So, as India considers adopting a robust cross-border insolvency framework through Part Z, it's important to look how other countries have already implemented such mechanisms. Global best practices not only validate the usefulness of the UNCITRAL model law, but also show how different legal systems have adapted it to suit their local realities. We'll focus on three key jurisdictions: the United States, the UK, and the Singapore. Each of these countries have has operationalized cross-border insolvency law effectively, and their experience holds valuable lessons for India. So the US adopted the UNCITRAL law in 2005 through Chapter 15 of its bankruptcy code. Chapter 15 deals specifically with cross-border insolvency and is now a cornerstone of American insolvency law when foreign elements are involved. Key features include foreign representatives can directly apply to US courts for recognition. Once recognized, foreign proceedings can stay creditor actions and allow cooperation. US courts coordinate with foreign courts through joint hearings, communication protocols, and enforcement support. A classic example was the insolvency of Nortel Networks, a global telecommunications company with operations in multiple countries. Courts in the US, Canada, and Europe conducted simultaneous proceedings. Chapter 15 allowed US courts to align with the others and avoid asset conflict. The outcome preserved value for creditors and showed the system's maturity. Coming to UK, so before Brexit, the UK was governed by the European Union's insolvency regulation. This provided automatic recognition of insolvency proceedings among EU countries. But after exiting the EU, the UK could no longer rely on this harmonization. To fill the gap, the UK reinforced its domestic rules under the cross-border insolvency regulations, which are based on the UNCITRAL Model Law. So British courts now rely on these rules to recognize foreign main proceedings, provide reliefs like moratorium, and coordinate with other jurisdictions through protocols. The UK's approach has been praised for balancing global cooperation with strong judicial oversight. British courts continue to work with foreign courts, and the legal profession there has developed deep expertise in cross-border insolvency. Coming to Singapore, Singapore adopted the UNCITRAL model law in 2017 and is often cited as a textbook example of how to make it work. Singapore has gone beyond mere adoption. It has actively positioned itself as a regional hub for insolvency and restructuring. To support this, the Singapore Supreme Court published detailed practice guidance on how cross-border cooperation should function. So Singapore's approach includes speedy recognition of foreign representatives, willingness to adopt cross-border protocols, court-to-court communication, and transparency. In the case of Jetta Jet, a cross-border airline insolvency, Singaporean courts coordinated seamlessly with US courts. The cooperation included shared timelines, respect for primary jurisdiction, and smooth asset handling. This kind of collaboration is exactly what India aims to achieve through Part C. So each of these jurisdictions succeeded because they adopted clear, adaptable laws, trained judges and professionals in international insolvency, encouraged courts to take initiatives in working with their foreign counterparts, published procedural guidance to ensure consistency. So the takeaway for India is that passing a law is only the first step. Implementation, training, and judicial willingness to coordinate are equally critical. So these global examples prove that ancestral works not because it's perfect, but because it's practical and adaptable. So India is increasingly integrated into the global economy. Indian companies raise money from foreign investors, list on international exchanges, and operate in overseas markets. Likewise, global companies are investing in India. So all of this requires a legal system that is internationally intelligible and cooperative. If India does not adopt a robust cross-border framework soon, it risks the following. One is creditor flight. Foreign lenders may stop extending credit to Indian firms. Forum shopping. Parties may shift to jurisdictions perceived as more cooperative. Asset loss. Due to lack of recognition, Indian professionals may lose control over foreign assets. So, in contrast, adoption will boost confidence, ensure predictability, and attract capital. It also shows that India is ready to align with global best practices, a must for any aspiring financial center. So, to conclude, whether we look at US Chapter 15, the UK's post Brexit regime, or Singapore's regional model, the message is clear. Cross border insolvency works when law, judiciary, and stakeholders cooperate. India doesn't need to reinvent the wheel. It needs to localize what works. And the Part G is a promising step in that direction. So we'll take a closer look at the key challenges in India must address before it can fully integrate such a framework from judicial readiness to policy inertia. Okay, so we have looked at what the ancestral model law offers, how countries like US, UK, and Singapore have adopted it, and how India has proposed Part C. But even if we were passed to Part Z tomorrow, several practical and structural challenges would still remain. These challenges must be acknowledged and addressed if India wants to truly implement an effective cross border insolvency regime. Because legislation alone doesn't create trust, execution does. So let's now examine the major obstacles that lie in India's path. So the first, sorry, yeah. So the first and most glaring issue is delay. Delay. Basically, it's delay. The Insolvency Law Committee submitted its report in 2018. It's now 2025, and Part Z is still not enacted. So this reflects the slow legislative momentum around insolvency reform and cross-border matters. Despite widespread support from professionals, courts, and stakeholders, the proposal has remained stuck in consultation and review stages. So every delay causes a real-world loss. Without a law in place, insolvency professionals are left to improvise, and foreign traders are left without confidence. So it also gives the impression that India is reactive, not proactive, in adapting to global norms. So even if Part Z is passed, the success of any cross-border framework depends heavily on the judiciary. And here lies the second challenge, limited familiarity and training. Most judges in the NCLT system have been trained under Indian commercial law. So they have little to no experience with international judicial cooperation, UNCITRAL principles, or cross border coordination. Without capacity building and knowledge dissemination, judges may hesitate to recognize foreign proceedings or allow foreign representatives access to the court. Worse, inconsistent rulings may emerge. Training, exposure, and clear procedural guidance will be critical for successful adoption. So, next comes the question of infrastructure. So, implementing cross border framework involves receiving foreign applications, translating documents, ensuring secure digital communications, enabling virtual hearings with foreign courts, and coordinating timelines across jurisdictions. None of this is currently in place. Even basic processes like authenticating a foreign insolvency order or facilitating a court to court call require ad hoc arrangements today. This lack of infrastructure could frustrate implementation and defeat the purpose of having a legal framework at all. So there's also an underlying fear among policymakers that recognizing foreign court orders might compromise India's judicial sovereignty. The question is often asked, what if a foreign court issues an order that contradicts Indian public policy? Should we be bound to comply? These fears are not entirely unfounded, but the truth is that the UNCITRAL model law and even into India's proposed Part Z already addresses this through the public interest exception. Yet the perception persists. Overcoming this will require both legal clarity and political reassurance that cooperation does not mean capitulation. So let's not forget the ecosystem of insolvency. Resolution professionals, legal counsels, creditors, valuers, and financial institutions. Most of these stakeholders are still unfamiliar with cross border insolvency frameworks. They don't know how to initiate recognition proceedings, how to deal with foreign practitioners, or even how to structure documents for foreign courts. This lack of capacity could lead to poor implementation. India will need workshops, mock simulations, international collaborations, and certification courses to get its ecosystem up to speed. So, another often overlooked challenge is the lack of coordination between different regulators. The IBBI, the RBI, SEBI, Ministry of Corporate Affairs, Ministry of Finance, all may get involved in cross border insolvency matters. For example, if a debtor holds foreign exchange or overseas assets, the RBI must be involved. If shares are traded overseas, SEBI's clearance may be required. Unless all these bodies are on the same page with standard protocols and clarity, coordination becomes bureaucratic and slow. So, to summarize, the challenges India faces are not just legal, they are operational, institutional, and cultural. From delayed legislation to lack of training, poor infrastructure to policy fragmentation, each barrier weakens the system. But none of these challenges are insurmountable. India already has the blueprint. What it now needs is urgency and ecosystem readiness. We'll discuss how to pull all this together, the key takeaways from this entire lecture, and discuss what lies ahead, both in India and for us or for the ecosystem as insolvency professionals, etc. Okay, so let's take a few moments to reflect on everything we have covered in today's session. We began by exploring why cross-border insolvency matters in globalized business environment. We looked at foundational concepts like COMI and the distinction between main and secondary proceedings. We examined the UNCITRAL Model Law, broke down its four pillars, and discussed how it enables legal cooperation across jurisdictions. We then delved deep into India's current legal position, looked at the Jet Airways case as a wake up call, and explored the proposed solution like Part Z. Finally, we studied global best practices and challenges that India needs to over, overcome to build a robust cross border insolvency regime. So here are the most important takeaways you should walk away with, in my opinion. One is cross-border insolvency is no longer optional. So as Indian companies globalize and foreign investors enter our markets, a framework for legal cooperation across borders has become essential. Next, India's current system is insufficient. Sections 234 and 235 of the IBC exist but are not notified or operational. They rely on treaties that don't exist and fail to address real world cross border challenges. Third is Jet Airways was a turning point. It exposed the gaps in our law, forced our judiciary to innovate, and highlighted the risks of improvisation in global insolvency cases. Four, Part Z is a comprehensive solution. So, based on ancestral model law, it introduces mechanisms for recognition, cooperation, access, and public policy protection, all without requiring treaties. Fifth is global benchmarks show the way forward. The US, UK, and Singapore have all implemented working models of cross border insolvency, proving that such systems are both feasible and beneficial. And sixth, India must act now. So, delaying reform risks losing greater confidence, international capital, and legal harmony. We need legislation, training, and infrastructure urgently. So, whether you're a law student, a practicing lawyer, a corporate finance advisor, or an insolvency professional, understanding cross border insolvency will become increasingly important in your career. As cross border trade and investment increases, disputes and defaults will too. You may find yourself representing a foreign creditor in Indian courts or helping an Indian company protect overseas assets. In all these cases, you'll need a firm grasp of recognition rules, protocol drafting, cooperation mechanisms, and due processes. So, this is not just an academic topic, it's an essential professional competency for anyone working in commercial or financial law today. So let's also touch upon a few questions you might face from anybody if you are into practice your clients. So can we file an insolvency application in India if a case is already pending abroad? So the answer is yes, but coordination is key. So under Part Z, one can seek recognition of the foreign proceeding and request local reliefs. So what if the foreign proceeding contradicts Indian law? So the answer is courts can deny recognition if it goes against Indian public policy. So can foreign professionals represent a company in Indian tribunals? Answer is yes, if recognized by the NCLT under Part Z's access provisions. Can foreign creditors participate in Indian CRP proceedings? Absolutely, and in fact, it's encouraged under a cross-border framework. How to stay updated and build expertise. So here's what you can do to stay updated ahead in the domain. So I would suggest you read key reports like Insolvency Committee Report 2018, which proposed Part Z. Study the Jet Airways Enclave judgment for practical insights into how courts handle absence of law, and go through the UNCITRAL Model Law Guide published by the United Nations, and follow the IBBF's website for updates, discussion papers, and consultations. And I would also suggest attend webinars and workshops hosted by IIIPI, ICAI, and other legal forums. The more you engage with real cases, procedural nuances, and global best practices, the better you will be at applying cross-border principles in real time. So let's pause here for a for a quick thinking. This is something that I want you to think. If you were advising the Indian government, would you recommend adopting the UNCITRAL model law through Part Z? So, I mean, whatever the answer is, you can think of the answer and the reason behind it. My question is, if you are advising Indian government, would you recommend adopting the UNCITRAL model law through Part Z? So now think, why did you choose your response? What concerns or opportunities came to your mind? So this is not a theoretical question. It's one that policymakers, judges, and practitioners are debating right now. So to conclude, cross-border insolvency is not merely a procedural or legal upgrade. It's a reflection of a country's economic maturity. It's a signal to the world that we are ready to cooperate, coordinate, and contribute to the global commerce on equal terms. India has a rare opportunity here to set the benchmark, not just to follow global best practices, but to innovate and lead. So, as students and professionals, your role in shaping, interpreting, and applying this law will be crucial. I hope this session has given you a structured, practical understanding of the topic. Um, yeah, I mean, thank you for joining. Okay, before we conclude, so I had some sample questions. If this is a live session, then I'd open up the floor. But since this is a recorded version, I would, for those who are watching, take this moment to pause and reflect on what resonated most with you in this entire lecture. And I have collected some sample questions which I have come across during similar sessions. So I'll just answer those questions. Okay. The what happens if India and another country uh, cla claim COMI? So what happens if both India and another country claim COMI? This is where the facts of the case. The answer is that this is where the facts of the case, not just the place of incorporation matters. So courts look at where the management is located, where key decisions are made, and where stakeholders expect proceedings to happen. Sometimes jurisdictions negotiate or differ to each other based on practical realities. So, another question is, can a creditor initiate proceedings in multiple countries simultaneously? The answer is yes, but they must declare such filings. So, under UNCITRAL and Part Z, courts can coordinate or limit overlapping actions to prevent conflicts. So, the next question is there a difference between recognition and enforcement? Yes, recognition means the court acknowledges that foreign proceedings exist and are valid. Enforcement is when that could actually applies or executes a foreign order locally. So, any other question you can approach. I hope this session has generated some curiosity. In if you're a student, consider researching recent cross-border cases. If you're already working in the insolvency or corporate law domain, um, try drafting mock protocols or studying how recognition applications are made abroad. So there's so much to explore from jurisdictional comparisons to drafting actual court-to-court communication proceedings or protocols. So I think with that we conclude our lecture on cross-border insolvency. I hope this session offered both conceptual clarity and practical direction. So as global insolvency becomes more common, I think anybody's knowledge of frameworks like UNCITRAL and proposed laws like Part Z will set them apart. So thank you once again for your time. Um, I look forward to seeing you again.